Definition of crime. In Islamic criminal law, there are words which are known to be used for any crime and offense. The words used are jurm, zarimah, and zinayah. Jurm is a root word which can be interpreted to the meaning of cutting off in literal. It signifies every Muslim not to do what has been prohibited by Sharia and to do what has been ordered by Sharia to be done, and for which the punishment of had and ta'zir has been prescribed, regardless of the relation of the human body or property. Jinayah signifies all kinds of every actions which are prohibited that it can cause injury. Crime is the violation of the divine law. What is meant by crime is that it can be defined as a prohibited act or omission of permitted act. In Islamic criminal law, there are various classifications of punishments which then later are divided into two classes which are known as had and ta'zir. Had here brings the meaning of prevention, restraint, or prohibition. Its further meaning is a punishment measure of which had definitely fixed by the lawgiver.
Classifications of crime. Had is one of the classifications of punishment in Islamic criminal law. Its plural Arabic term is known as hudud. Its meaning can be literally defined as limitation. For example, the limits ordained by the lawgiver. On legal terminology, it is a punishment which has been defined in Sharia and is also fixed. Hudud is a kind of fixed punishment prescribed by Allah in the exercise of His exclusive right. Hard is the fixed punishment because this can neither be increased nor decreased by anybody or agency. Under the Islamic penal law, hudud crimes are stated as the most serious, grave, and aggravated. In Quran and Sunnah, these crimes and penalties has been defined and prescribed. The punishment for the crime or offense shall be imposed to the guilty offender accurately as how it has been prescribed, as it has been said that the prosecution for such crime is mandatory. The hudud punishment are rights which belongs to Allah. It is because that they have been promulgated for the protection of the society against crimes. This punishment ensures the welfare of the society, its stability, and the attainment of a rule of law. The jurists are unanimous that hudud offences, which described as hukuk lillahi ta'ala, are sarikah, hirabah, zina, shrab, kazaf, and al-baghi.
The definition of shrub is drinking wine. Intoxication here means out of sense by the use of liquor, for example, wine. An intoxicated person can also have the same effect of not being in the right mind, not only by drinking liquor like wine, but also anything that can effectively work the same as the wine itself. According to Abu Hanifah, he stated that the intoxicated one is the one who is out of sense, incapable of understanding anything and unable to distinguish things like male or female in heaven or earth. The original word of khamar means only wine, but there are various meanings according to the reference of the majority of the jurists. It is accurately defined as liquor made from wheat, barley, dried grapes or dates, rice or any other substance. The jury stated that Muslims are prohibited from drinking regardless of it causing intoxication or not. This can be referred in the hadith. Every intoxicant is wine, and every wine is unlawful. But in this matter, Abu Hanifah, on the other hand, draw distinction between wine and the other liquors, where if we refer according to his school, it is stated that he differed drinking wine and drinking other liquor, as it is a total prohibition to drink wine, whether the person intoxicates or not, while it is not punishable for the use of other liquors, unless the one drinking it drinks until he intoxicates.
History of the prohibition of wine. The prohibition of the alcoholic drink is seen to be concerned as it was prohibited after one incident that happened during the time of the Prophet Muhammad ﷺ, and it was recorded in the Sunni hadith literature in hadith found in 𝘊𝘂𝘧𝘐𝘯𝘵. This happened when some companions of the Prophet Muhammad ﷺ were guests at a meal and drank wine, and then that was the verse in the Quran was subsequently revealed. Narrated Abu Abdurrahman as-Sulami that Ali bin Abi Talib said, Abdurrahman bin Auf prepared some food for which he invited us and gave us some wine to drink. The wine began to affect us, and when it was time to perform salat, so they encouraged me to lead, and I recited, Say, O you disbelievers, I do not worship what you worship, and we worship what we worship. So Allah Most High revealed, O who you believe, do not approach Salat when you are in drunken state until you know what you are saying.
During the time of Prophet Muhammad SAW, there was no fixed punishment for the offender. In that time, the punishment for the offender is that the offender happened to normally be beaten by shoes, kicked and lashed with sticks and ropes, and the maximum punishment was 40 stripes. This was reported by Anas bin Malik, where he stated that the Prophet ﷺ beat the drunkard who was brought to him with palm branches for 40 times. The punishment for the intoxicated person is indeed mandatory, as it can be seen in the hadith where the Prophet Muhammad ﷺ said, "Flog whoever drinks wine." While according to the jurist, Abu Bakr gave 40 lashes to the offender as punishment, and Omar did likewise during the first year of his caliphate, but the numbers of the offence was increased unprecedentedly. He then consulted the companions, Ali and Abdul Rahman, and they suggested that the punishment for the offence should be parallel with the punishment of qazaf, and then subsequently he inflicted with 80 lashes. Differences regarding to the above matter by the jurist. According to Imam Abu Hanifah and Malik, the Prophet Muhammad SAW had in one occasion beat an offender with both of his shoes 40 times, in which the punishment will be equivalent with 80 lashes, meaning that here 80 lashes are acts according to the Sunnah. In addition, Shafi'i and Imam Ahmad said the maximum punishment was 40 times, and the punishment of qiyas cannot have comparison with the other offences. Last but not least, according to Ibn Taymiyyah, it has been said that the original punishment must be 40. The additional 40 can only be imposed by the judge to the offender if the offender does not want to repent or refrain from repeating the crime.
Situations where there will be no hard punishment. The first one is when the alcoholic drink is used for the purpose of sickness, and this is according to the different views by the jurists. The second one is if it takes it without the criminal intention, and the third one is if the wine is taken by mistake.
Intoxication can affect criminal responsibility in several ways. In some cases, it could result in a complete acquittal, while in others, the accused could receive a qualified acquittal. In still others, the accused may have his charge of murder reduced to culpable homicide, not amounting to murder. The defense of intoxication is spelled out in Section 85 and 86 of Penal Code, which read as follows. Section 85 Clause 1, save as provided in this section and in Section 86, intoxication shall not constitute a defense to any criminal charge. Section 85 Clause 2, intoxication shall be a defense to any criminal charge if by reason thereof the person charged at the time of the act or omission complained of did not know that such act or omission was wrong or did not know what he was doing, and the state of intoxication was caused without his consent by malicious or negligent act of another person, or the person charged was, by reason of intoxication, insane temporarily or otherwise at the time of such act or omission. Section 86 Clause 1, where the defense under subsection 85 Clause 2 is established, then in a case falling under paragraph Clause A, thereof the accused person shall be acquitted, and in case falling under paragraph Clause B, Section 84 of this code and Section 347 and 348 of the CPC shall apply. Section 86 Clause 2, intoxication shall be taken into account for the purpose of determining whether the person charged had formed any intention, specific or otherwise, in the absence of which he would not be guilty of the offence. Section 86 Clause 3, for the purpose of this section and Section 85, intoxication shall be deemed to include a state produced by narcotics or drugs. There are three forms of defense of intoxication that can be extracted from the provision. First, where a third party had maliciously or negligently caused the accused to become intoxicated to the extent of not knowing the act to be wrong or what he was doing. This is sometimes described as involuntary intoxication. Second, where the accused was severely intoxicated as to have been insane at the time of the alleged crime. An accused will be acquitted of a crime which has intention as an element should intoxication have prevented him from having that intention. In English law, intoxication operates as a complete defense, not as mitigating circumstance. For example, reducing murder to manslaughter. If there is no lesser offense, it can be a complete defense. For example, in the case of theft. However, under the penal code, intoxication operates as a complete defense, not as mitigating circumstance. Except in a few cases like Subha Singh against PP, Court of Appeal held that defense of intoxication not a complete defense but only as a mitigating factor to reduce a charge of murder to one of culpable homicide not amounting to murder. In the case of Tan Hun Song against PP, Court held that intoxication would negate the mens rea of intention, murder charge reduced. These two cases was decided based on a total reliance of English law and overlooked the penal code position on the matter.
Move to the drunk driver. According to study done by the Malaysian Institute of Road Safety Research, about 23.3% of drivers in a fatal accident were tested positive for alcohol. According to the study done in 2012, a drunk driver is 30 times more likely to cause an accident compared to a sober one. The amount of alcohol in person that enough to get into hot water is covered under Section 45G of the Road Transport Act 1987. Prescribed limit means A. 35 micrograms of alcohol in 100 milliliters of breath, B. 80 milligrams of alcohol in 100 milliliters of blood, or C. 107 milligrams of alcohol in 100 milliliters of urine. The number can be misleading because different people can reach 0.08%. PAC because of different physics and metabolism. That brings to Section 45B of the Road Transport Act 1987, which gives power to the police to administer breath tests. Breath tests are not the only way to test for PAC, but they are the most common one because breathalyzers are portable. Any police officer in uniform can administer a breath test if they are suspect. The first one, the person has committed an offense under Section 44 or 45 or 45A, drunk driving in charge of vehicle while drunk, or second one, the person has been involved in a traffic accident involving one or more vehicle. Under Section 45B of the Road Transport Act 1987, Clause 5, a police officer in uniform may arrest a person without warrant if Clause A, as a result of a breath test, he has reasonable cause to suspect that the proportion of alcohol in that person's breath, blood, or urine exceed the prescribed limit, or Clause B, that person has failed to provide a specimen of breath for a breath test when required to do so in pursuance of this section, and the police officer has reasonable cause to suspect that he has alcohol in his body, but a person shall not be arrested by virtue of this subsection when he is at hospital as a patient. Section 43 of the same Act, Section 43 says that a person who drives without due care and attention or without reasonable consideration for another person using the road is guilty of an offense. Drunk driving is certainly punishable under this section, and if found guilty, offender can expect to pay a fine of up to 10,000 ringgit and a maximum period of imprisonment of 12 months. Section 44 of the Road Transport Act 1987 is the most direct way that any person can be liable for a drunk driving charge. Clause 1. Any person who, when driving a motor vehicle on a road or public place, Clause A, is under the influence of intoxicating liquor or drug to such an extent as to be incapable of having a proper control of the vehicle, or Clause B, has so much alcohol in his body that the proportion of in his breath, blood, or urine exceed the prescribed limit and causes the death of or injury to any person shall be guilty of an offense. This section is worded in such a way that a person will be guilty whether they are obviously drunk and driving or they don't look drunk but their BAC level exceed the legal limit. Upon conviction under Section 44, the offender has to pay a fine of not less than 8,000 ringgit up to a maximum of 20,000 ringgit and a jail time of a minimum of 3 years. Section 45 and 45A of the Road Transport Act 1987. Any person can commit an offense merely by being in the car if the BAC levels are too high. Section 45 and 45A give the police officer certain powers of discretion and are more specifically targeted at the people who are in charge of a vehicle when they are intoxicated or have BAC levels above the prescribed limits. If found guilty under Section 45 or 45A, the offender may be fined up to 1,000 ringgit Malaysia and imprisonment of up to 3 months on the first conviction. Subsequent offences will net the offender a fine between 2,000 ringgit and 6,000 ringgit Malaysia and jail time of up to 12 months.
Comparison of intoxication between Malaysian law and Islamic law. In Islamic law and Malaysian law, the provisions for the sentence of whipping exist. There are clear provisions pertaining to whipping only on male offenders in the Criminal Procedure Code 1999. This is because, according to Section 289 of Criminal Procedure Code 1999, stated that female offenders are exempted from it. However, in Islamic law, both male and female offenders will be imposed in this sentence. This is because if they have committed any crime such as intoxication, all of the offenders shall suffer the same sentence. Besides that, in Malaysian law, there are also punishments for drunk driver, which is according to Section 43 of the Road Transport Act. If the person is guilty, the offender will have to pay a fine of up to Rm 10,000 and a maximum period of imprisonment of 12 months. According to Section 44, the offender has to pay a fine not less than Rm 8,000 up to a maximum of Rm 20,000 and jail time of a minimum of 3 years. However, if the offender found guilty under Section 45 or 45A of the Road Transport Act, he or she has to pay a fine of up to Rm 1,000 and imprisonment of up to 3 months on the first conviction, and he or she has to pay a fine between Rm 2,000 and Rm 6,000 and jail time of up to 12 months for the next conviction.